This is now years of going through the court system with Miss Archer, and pretty much waiting every day for something new to come in the mail. And then Felix has already been taken to court once, and I don't want to put him through anything else. I just want some stability.
He was willing to forfeit his time and still have visitation with our son at my, what's the word?
Dad violated legal residence provision of the court order by moving his legal residence and subsequently the child 100 miles away without mom's consent or the court's permission.
This is a matter of Natasha Meyerhofer Archer versus Jesse Thinnell. We're here today on a complaint filed by Miss Meyerhofer Archer that Mr. Thinnell violated the legal residence provision of their court order by moving his legal residence and subsequently the child more than 100 miles away without her consent or the court's permission. A 21-day notice was sent to parties on November 16th, 2023. Mr. Thinnell responded to that notice on December 4th, 2023. He has moved to Midland, Michigan, and as part of and it was due to housing loss from his former residence, he indicated, as well as employment down in Midland. As part of a December 15th, 2020 order for custody support and parenting time, the parties have one minor child, Felix, who is, I believe, 5 years old, in which they share joint legal and shared physical custody, and they alternate weeks of parenting time, exchanging on Mondays. The provision in question is that under the residence provision, when the court order was established, the plaintiff, Miss Meyerhofer Archer, lived in Ellsworth, Michigan, and Mr. Thinnell lived in East Jordan, Michigan.
Okay, thank you. Mr. Thinnell, are you able to hear me?
Yes.
Okay. So I read your response to the show cause, and do you have a copy of that with you?
Yes, I do.
Okay, so I'm looking at it now, and it says that you informed Miss Archer of your signing the lease for the Midland place, and that you informed her of that on September 25th. Is that accurate?
Yes.
Okay. And then how did she respond after you informed her of that?
Just with an okay.
Anything else?
That was it. And then on November 3rd, because I had informed her I would update the address on the AppClose app we use to communicate, and I did. I just didn't realize she couldn't see my end of it. I had to actually update it under Felix. So November 3rd, she asked if I had updated it, which then I realized that she couldn't see it, so I updated it, and that was all I ever heard about it.
You didn't hear anything else from Miss Archer between then and when you got the order to show cause?
No, not on the move. No.
Are you, what's going on with parenting time right now?
Parenting time was reduced to 2 weekends a month. And it was a very hard decision to make, but with everything, I'm going to forfeit my parenting time for the time being, retain my legal 50-50 custody. But
why are you choosing to forfeit your parenting time?
For Felix's stability, for my family's stability, this is now years of going through the court system with Miss Archer, and pretty much waiting every day for something new to come in the mail. And then Felix has already been taken to court once, and I don't want to put him through anything else. I just want some stability and peace between us. If it requires the time I see Felix to be in Natasha's hands for things to calm down so we can start hopefully co-parenting properly, that this is the only option I see that's going to help any.
Okay, thank you. So Miss Archer, do you consent to Mr. Thinnell moving down to Midland?
I did not know.
Okay. And did you tell him, or did you send him something in writing saying that you didn't agree?
I did not. As soon as I was informed of the location that he was moving, I reached out to a friend of the court, caseworker Julie White, and informed her. in the past, Mr. Thinnell and I have not been able to have decent conversations regarding things like this. And like he had said, I was not told of the location of his move until November 3rd. And you'll see in what I sent you that I reached out to Julie shortly thereafter, just
When
kind
w-
of asking what my solution would be there.
When would you say you reached out to Miss White?
Within 48 hours of knowledge of location.
Okay, so on or about September 25th.
No, sir, on November 3rd, around November.
I
I
see.
was
Okay.
told
Okay.
September 25th that he would be moving, and that's all that was said in the note.
Okay. All right. And Ms. Archer, what are you asking for today?
Just for Mr. Thinnell to be held accountable for his violation.
All right. Mr. Thinnell, was there anything else that you wanted to say today in response to the order to show cause?
Yes, if I would have been made aware that Miss Archer had any complaint with it, I definitely would have motioned with the court. So, but honestly, I didn't know she had any issue with the move. I understand she didn't know the location, and that is on me until a month later. But I would have absolutely called up Julie right away and ended up filing the motion in time so that this wouldn't have been a contempt issue. So
Okay.
I had no knowledge that was where I needed to proceed next. I thought everything was okay until I got the motion to show cause.
Okay. So this has been a show cause hearing. This is Archer v. Thinnell, file number 20-8620-DC. The parties in this case are the parents of one child. The terms of the relevant order have already been stated by Ms. Mullen. The complaint at this point is that Mr. Thinnell changed his legal residence with the child in violation of MCL 722.31. That statute states in pertinent part that a child whose parental custody is governed by the court order has, for the purposes of this section, a legal residence with each parent, except as otherwise provided in this section. A parent of a child whose custody is governed by court order shall not change a legal residence of the child to a location that is more than 100 miles from the child's legal residence at the time of the commencement of the action in which the order is issued. In this particular case, at the time that this action was begun, defendant was residing more than 100 radial miles from his current residence in Midland, Michigan. The defendant moved to Midland in September. And at this point, the court is looking to subsection 2 of MCL 722.31, which states a parent's change of a child's legal residence is not restricted if the other parent consents to the residence change. And so there was a question as to whether a plaintiff consented to the residence change. Mr. Thinnell communicated to Ms. Archer on or about September 25th that he was going to be moving to Midland. Ms. Archer responded with okay. However, she didn't actually see the update of the new Midland address until November 3rd, at which point Ms. Archer promptly contacted Ms. White to indicate that she did not in fact agree with that residence change. Mr. Thinnell just stated that he would have filed the appropriate motion to change domicile had he been aware that Ms. Archer did not agree with the legal residence change. But the order to show cause was issued back on December 14th. And here it is, January 24th, and Mr. Thinnell has had time to file the appropriate motion. He's been on notice that plaintiff did not agree with the legal residence change since he's received the order to show cause, which the court is assuming would have been at the very least by the end of December. Certainly that's sufficient time to file the motion. Mr. Thinnell understood that he would have needed to file if plaintiff didn't agree. So at this point, the court really has no choice but to find that Mr. Thinnell is in contempt of court for violation of MCL 722.31. The question at this time is what sanction would be appropriate in this case. Mr. Thinnell is not exercising his parenting time, and so it's not a case where I was originally thinking that I would make an exchange point that was going to be close to Miss Archer's residence in Ellsworth, since Mr. Thinnell did not file the appropriate motion, and it was his choice to move to Midland. I was considering putting most of the burden of transportation on him, but for this court to issue that order at this point would kind of be moot because there's not even any parenting time occurring. I mean, Miss Archer, do you envision parenting time occurring in this case?
Eventually we had spoken through the AppClose app that he was willing to forfeit his time and still have visitation with our son at my, what's the word? At my okay, pretty much. Which is perfectly fine with me. And we have been doing exchanges in Mansalona, which is only about 30 minutes from my residence. So the exchange was not the issue. But like you said, at this point, it would be moot since he is forfeiting his visitation rights.
All right, so in that case, I'm just going to make the sanction $100, which will be collected through the child support order. That will conclude our hearing for today. Thank you.
Thank you.
Thank you.
Thank you.
We have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis.
Some payment is better than nothing. No payment is kind of like a middle finger to those other two children that you have, and that's not appropriate at all.